Olá, olá a todos, olá a todas, sejam muito bem-vindos aqui ao nosso evento de lançamento da obra do autor Joshua Walker, o On Legal AI, a Inteligência Artificial no Direito. Eu, Alexandre Pacheco da Silva, professor aqui da FGV Direito SP, Escola de Direito de São Paulo da Fundação Getúlio Vargas, tenho o prazer de recebê-los aqui nesse evento, à distância, mas com todo o calor que a gente pode entregar aqui para vocês à distância, para que a gente possa ter uma tarde de excelentes debates e discussões. Eu, junto com a professora Marina Pfefferbaum, que está aqui com a gente, nós coordenamos o Centro de Ensino e Pesquisa e Inovação, o FGV CEP. O FGV CEP, ele é o braço da Escola de Direito de São Paulo da Fundação Getúlio Vargas, da FGV Direito SP, que cuida de projetos envolvendo direito e novas tecnologias, em alguns casos nem tão novas assim, para a gente tratar aqui entre projetos, tanto na área de ensino quanto na área de pesquisa. A nossa intenção com o encontro de hoje é a gente dar conta do tema inteligência artificial no campo jurídico e explorar uma das obras mais relevantes que a gente já teve lançada ali em língua portuguesa, quais são esses impactos do ponto de vista, obviamente, do direito nacional e da profissão jurídica. Mas, para além disso, só para explicar um pouquinho o que é o CEP, dentro dessa brevíssima introdução, o CEP, como Centro de Ensino e Pesquisa, cuida dos projetos que, do ponto de vista da construção do conhecimento, estão na ponta dos debates jurídicos entre direito e tecnologia, portanto, somos um centro de pesquisa. Ao mesmo tempo, cuidamos de converter todas essas discussões de ponta em sala de aula, criando ali cursos e iniciativas ali de ensino que possam ali colocar nossos alunos e os membros da nossa comunidade na fronteira do conhecimento sobre direito e tecnologia. Eu já vou passar a palavra aqui para minha colega, amiga e, obviamente, co-coordenadora do Centro de Ensino, Pesquisa e Inovação, para que ela dê as boas-vindas também no nosso evento. E só para explicar um pouquinho qual que é a nossa dinâmica, a gente tem essa breve introdução com a Marina e também com o Alexandre Zavaglia, líder dessa iniciativa junto conosco, para que a gente possa, obviamente, ouvir o nosso convidado de honra, o professor Joshua Walker, autor do livro lançado hoje. Má, é com você. Aliás, antes de passar a palavra para você, eu tenho um dever de ofício aqui, que é falar o disclaimer ali dos nossos eventos aqui da Fundação Getúlio Vargas, e em seguida eu já passo a palavra para você. Bom, só para dizer aqui para todos os nossos presentes, que as manifestações expressas por integrantes dos quadros da Fundação Getúlio Vargas e por convidados que participam dos eventos e transmissões online, representam exclusivamente as opiniões de seus autores e não necessariamente a posição institucional da FGV. Reiteramos também que todos aqui presentes concordam em participar desse evento de forma espontânea e, com isso, autorizam o uso de sua imagem para essa transmissão, que ficará disponível posteriormente nos canais oficiais da FGV. Má, a palavra está com você. Sejam muito bem-vindos aqui ao nosso evento.
Muito obrigada, Alexandre. Agradeço primeiro, boa tarde a todos, a todas, boa tarde, Alexandre e Joshua. É um momento muito especial para nós do CEP, de estarmos juntos aqui fazendo o lançamento desse livro, porque uma das agendas centrais aqui do nosso centro de pesquisa é justamente poder trazer conhecimento, trazer inovação para a sociedade como um todo, e muitas vezes por estarmos no sul global e termos algumas barreiras, muitas vezes com o inglês, é importante que a gente possa trazer essa oportunidade para que todas e todos tenham maior acesso a essas obras. Acho muito importante dizer também que ao longo desse evento nós gostaríamos de receber perguntas sobre a obra, sobre o debate que a gente vai ter aqui hoje. Então, abaixo a gente tem aqui o slide, que vocês podem, por favor, mandar essas perguntas, que a gente vai tentar o máximo possível atendê-los. E também queria dizer que esse projeto ele não foi só especial por ter tido contato com o Joshua, que é detalhista em todo o processo, querendo sempre entregar o melhor possível, mas também o convívio com o Alexandre Zavaglia, que foi o líder dessa iniciativa, que aproximou a escola a esses canais e fez com tanta dedicação esse projeto de fato acontecer. E também queria agradecer imensamente a Ana Carolina, que que executou com a gente essa oportunidade, nossa pesquisadora desse projeto. Então, muito obrigada, Ana Carolina, pela sua dedicação e empenho, e, claro, o meu super companheiro, Alexandre Pacheco, de todos os outros projetos. Então, queria deixar esse registro de muito carinho e muita gratidão por esse momento, tá bom? Vou passar aqui a palavra para o Alexandre Zavag.
Bom, boa tarde a todos. Eu que tenho o privilégio de fazer parte aqui do CEPI, conviver com o Alexandre, com a Marina, e poder, né, trazer um pouco, agradecer também muito a Ana Carolina, que foi essencial para esse projeto dar certo, e poder trazer um pouco, né, disso que a gente tem estudado, aprendido ao longo dos últimos anos, né, trabalhando com tecnologia, estudando regulação, estudando também o impacto no próprio direito do uso de inteligência artificial e também, né, na nossa profissão, na prestação de serviços jurídicos. E eu tive a oportunidade de conhecer esse livro aí quando eu fui lá para a Universidade de Stanford. O Joshua é um dos fundadores do Codex, que é um dos laboratórios, né, de direito e tecnologia mais importantes do mundo. E depois a gente teve a oportunidade de convidá-lo aqui para o Brasil para estudar esse projeto, mas o Joshua não só ajudou a fundar esse laboratório, como também fundou a primeira empresa de analytics do mundo, né, chamado Lex Machina, e depois foi, né, comprado aí por uma grande empresa de tecnologia. Então, tudo isso que a gente hoje escuta falar, como é que um juiz pensa, como é que o advogado pensa, né, tudo isso começou com essa primeira iniciativa mundial. E também agradecer, em nome aqui da GV, os nossos apoiadores, né, Pinheiro Neto, Matos Filho, Urbano Vitalino, Peixoto e Cury, PG Advogados também, Finop Ustra, o César, o IASP, a ASP, né, que também apoiaram bastante para tudo isso acontecer, e passar aqui para o Joshua, que é quem a gente quer escutar. So, hi, Jay, it's a great pleasure to have you here again with us. I'm just telling that I saw the book for the first time when I went to Stanford at Codex and went to research what was really going on, what's been reading about artificial intelligence. And then we have the opportunity to invite you to come here to Brazil in 2019. And after a few months, we have this discussion of the project of the Brazilian edition of On Legal AI, here at CEPI and in partnership with Thomson Reuters, Revista dos Tribunais. So it took more than a year of the project to choose the professional involved. Marina was telling them to, in addition to during this time, we talk a lot to understand your care with the translation, with the expressions and jokes, which are different according to the culture of each country, and your concern for actually use this book to collaborate with discussions here about AI here in Brazil. So, so in this changing world, with all this new technology, and I just want to leave a first question for you. Because we are here in a university, so how to train people for these new jobs, for these new business models, for these new conflicts and solutions, for this AI future. So how to prepare ourselves as a professional, as teachers, and of course, as a country. So we are here anxious to hear from you, your story, and of course, to have your insights for these discussions. Thank you very much again, Jay.
Obrigado so much. It is, thank you so much. And again, I think that's a discussion. You know, no one has all the answers, but we can all learn from each other. So I look forward to learning from you, and hopefully I have some things to share and things to avoid, and some good things too. I was asked by the organizers to talk about three things today, and I know you're here to get to it. One was experience in relation to legal AI. One was experience. The second was the purpose of this. And the third was the challenges. And I've got 25 minutes, but when I looked at the material that I wrote in response, I think I'd need 25 hours to just begin and really realistically 25 years for us to make a dent in it. And so those are the different time horizons we have to work with. Before getting to any of those, I just want to thank again, this is our first project here together, and I'm so thrilled with the results. As Alex said, funds and humor might seem like a sideline, but lawyers and legal academics like me, we are notorious for being boring. So if we can make a little bit of humor as well, I think it'll make the educational content digest better. That's the intention anyway. So, but I hope that there are no money back guarantees if you don't laugh. I want to thank Fastcase, first of all, Thomson Reuters for making this project possible in Brazil, FGV and the coordinators, of course, and for hosting this session. And I'm going to mispronounce the law firm names, but I do want to say them out loud and just say thank you. Pinheiro Nieto, Matus Fiu, Urbano Vitalino, Peixoto Curry, that's the one I'm pretty sure I'm mispronouncing, but please, thank you. And Pinocchio.
You're doing pretty well.
What's that? Okay, thank you. I'm trying my best. And my Brazilian was better when I was there in 2019. So I hope, God willing, we can come back soon. So, there was an ask for three things that are related to legal AI. One was experience, one was purpose, and the third was challenges. But they didn't say it had to be my experience necessarily to talk about today. And in fact, there's a lot in the book itself. And so they also didn't say whether I could talk about past, present, or future experience. And I think those are important in this context as well, to talk about the timeline we're in and how we use data and modeling to model out, what we're going to be doing in the next few years to the next 20 years of our careers, if we're able to have them. I would say that my own experience, it's better written in the book than I can say right here. The strange thing sometimes is that if sometimes our works can exceed ourselves, and I'm certainly no one special, but the book has a lot of really unique experience in it, I think, that's going to be helpful to people. And in building the original codex and in Lex Machina, they're just interesting stories about how we help people and how we encounter obstacles and address them. And I would say that that's right there. And it's just the tracing of one human lawyer through a number of different scenarios. And I think it's going to be relevant to all of you. So when I'm thinking about experience, instead of my own, I really want to think about individual stories. But it's also occurred to me that there's several hundred people on this WebEx that are watching it, and likely more later. For every 3 stories I have, each of you there's 300 in this gathering that we can go to and address. And I think every single one of you listening has a story about law gone wrong, or an area where you think you have an instinct that may be correct, that legal data and empiricism can help and improve it. And so I think instead of 3 stories, I can talk about 3 archetypes. What do I mean? So deals, it's one archetypal type of story in the law. The second is disputes. And the third we'll call governance. In my experience, forgetting about legal AI for the moment, deals contracting is kind of a train wreck, not just in the US, but globally. There's really limited relationships between how the intention of the parties and what happens in the contract and the actual agreement and how the parties fulfill it. There's almost a disconnection or a lobotomy between real life, what's happening behind the scenes, and the contractual provisions and the artifact that's there. And some people might say, well, you have the real things of what happens, and the contract is just there in case something goes badly wrong or someone tries to cheat someone else. But really, those two things should be a little more aligned, and they should correlate to each other. And we haven't done a spectacular job doing that. It's true that we're better than, caveman lawyer clubbing each other with things and as a means of dispute resolution, or something in the shadow of the fear of the club. but the artifact of the contract doesn't really match the reality of what's happening economically, the behavior of the parties, all that stuff. We need exogenous mechanisms to try to address that disparity to make this legal artifact more useful and more helpful to people. So I think that's one archetype deals that is broken and that's ripe for legal AI and empirical data and engineering platforms to address a little more comfortably. And again, it may be that we have fewer train wrecks in terms of the transactions themselves, but you can have happier users and a better interface for how we interact with the law, as opposed to this bifurcation of here's the contract, and then there's people here that never look at the contract again and don't deal with it. How do we do that differently so there's less of a chasm between the legal and what happens in real life? In disputes, same thing. We've all seen cataclysms in the dispute areas. They could be lawsuits, they could be administrative disputes. And in every category, we've seen something gone badly wrong. Either a lawyer that gets completely out of hand or that is lying, or something worse, there's a systemic problem in how the claim is generated from the first part, or there are not enough claims. Again, we have to be unbiased and empirical about what is a good litigation system, right? We can't assume that the UK has the best one or America or Brazil have the best ones. We don't actually know. And we have to establish a baseline of truth as to what we're trying to achieve in any given system and leverage experts and know-how in the gut as well as the vast data fields. Should people have infinite access to dispute resolution mechanisms in the courts? What are the best means of determining those disputes? And what's the best scope of your claim once you go in? What's the best process? And, again, in patent, as we talked about in the book, it was a very simple example. And it was a very highly, well litigated area, right? Because big companies were suing each other and there was a lot at stake. So they could afford, really well developed legal processes and counsel who were generating them, and analysis of what was going on behind the scenes. And we determined there were some real problems in how certain patent claims got generated. And in theory, the White House and the executive branch and the judiciary could address those and deal with them. That story is just one story in an ocean of problems and imperfections in the system. To really optimize this, we have to teach civil procedure using empirical data to say, here is this procedure and here's what happens in real life with this. In theory, you could knock out bad expert witnesses. In reality, in some states, you can only do it 20% of the time on this legal basis. Like, we really don't know, going back to Alex's question at the beginning, we really don't know what the best approach this is, because we don't study these things from a complete perspective. We look at it from a rules-based reality, but we don't look at the reality of those rules hitting the ground and how they're applied in real life. And are some judges, do they seemingly have a more effective process than others? How do you pull the data for that? Even if you're processing something inevitable, justice, how do you look at the procedures and the mechanisms in a way that can allow the judges to focus on that, as opposed to pushing paper or being overwhelmed with administration that may or may not be helpful to things? How do you uncover, again, unethical lawyers who are just doing things that are for improper purposes? They're profound problems, but having data attached to those are inevitably going to be very useful. The third archetype, the third story, is governance. And here I will borrow a little bit from the book, though. Again, I encourage you to read it. It's better than me, as I said, exceeds my wisdom. But I'm going to go to the word cyber. So in the book, I talk a little bit about this. Cyber, we all know, thanks to William Gibson, who is a very eclectic and amazing science fiction writer, coined the term cyberspace. But that's not where cyber is rooted, actually. Cyber is rooted in the word Kubernetes, which is a Greek word. It means steersman or oarsman. And that, if you go to the expression head of state or it actually connects to that, and you say the steersman for the head of the state is something called a gubernator, gubernates, or gubernator, or a governor. So the same word for mechanical governor in a system that modulates itself and like a steam engine, balancing its load and its pressure and its output, same thing for a state. And so the term cybernetics actually refers to feedback systems. You have one output here and it has another feedback here, and it somehow optimizes itself. So you have a living organism, or you have a machine that works, or you have a train that runs and stays within its boundaries. And if there's an error, it can be addressed safely. Norbert Wiener out of MIT invented the term cybernetics, and he was a fan of a guy named Leibniz. Leibniz, if you read the book and others, he was a polymath, but he was first a lawyer, and he studied law. He had multiple degrees, but one of his main foci was in legal studies. And he had been sent to the court of the King of France, Louis XIV. And Louis XIV was a kind of a rough guy. And his boss, who was the head of a German principality, was trying to get him to go to Louis XIV, Louis XIV, and say, don't invade us, basically. Leibniz imagined a system, a machine that would, once inputted with the background or the data behind a dispute, you could crank the wheel and the parties would compute the result, and you would have the answers of who is right at the end of the day. And that, gentle people could resolve disputes this way. Instead, Louis XIV went to war and attacked Prussia, or what became Prussia, and it was a nightmare. But Leibniz's dream, in the process of trying to invent it, he invented something called binary, or the modern use of binary. And binary became the tool that people like Norbert Wiener used to develop modern computer science. But cybernetics means governor or governance. And that's a very, very useful concept in the topics that we're using. It's a fundamental concept. And I'm going to use it to argue that really, when you go back to its origin and why it's there, law and computer science are the same thing. They're identical. They're not different. And that creates profound opportunities for us to leverage these platforms. What's a deal? A deal is just an optimization problem between two parties. It's a classic computer science problem. What's a dispute? Well, a dispute is a problem. It's a disagreement. It's an uncertainty. But a legal system, abstractly, is just an algorithm for resolving disputes. We know it's much more than that. We know it's chasing something that justice, that it's profoundly important, profoundly difficult to pin down, but it's also a mechanism for resolving disputes without caveman lawyer. So, that reality enables us to actually use some of these techniques to help think about how we can improve our systems. If we have enough humility, and if we maintain the art and the humanity behind the law, not just and not descend into a well of mathematics that isn't aware of those human issues. Most of government is really an admixture of those two archetypes, deals and disputes. It's a tyranny, or it's both. But if we can think about this as from a systemic perspective, some of our most base archetypal problems in the law, whether they're transactional, whether litigation, whether it's M&A, financial disputes, financial objects, financial contracting, from blockchain to the earliest contracts, they all start to make sense again. So that's a little bit of the experience and the experience that I've had, but I think it probably speaks to some of the cases that you're addressing right now. And again, there's an infinite number of ways we can apply those. So what's the purpose of this? Why are we here? I think the answer is very simple. On a macro level, the legal AI movement, what we're talking about today, we're here to save lives and help the economy. Two things: save lives and help the economy. It's incredibly simple. There's no doubt that if we improve our systems, whether for dispute resolution, administration, contracting, we make it more available to people, We make the system more equilibrated, right? If you can imagine the cybernetics metaphor. We're going to save hundreds of thousands of lives, if not millions of lives in Brazil. There are hundreds of thousands, if not millions of lives at stake if we do this right. No legal system is optimized, no legal system is perfect, and there are clearly substantial improvements we can make without regard to politics or which interest group, rich or poor, which ethnic group. Those things are irrelevant. There's no doubt that we can save hundreds of thousands or millions of lives if we do this right and if we're committed. Secondly, helping the economy. There's no doubt that we waste over 10% of our economy a year on inefficient legal practices. There's no doubt we could help people better. We can optimize, we can help show them this is a better legal path than the one they're on with better UX and UIs. That's, to me, it's axiomatic, but I'm happy to step in and argue that point. But if we take that as an axiom and we combine those two, improving people's lives is kind of somewhere in the middle. So how do we do that? How do you go about thinking about that in terms of on a practical level? There's first the citizens, right? So if you start with a citizen or the client and derive from there, it all starts to make sense. The government agents, legal agents, judicial agents, executive, legislative, and then entities. And you can think of, it's a little bit dangerous to consider a corporate entity the same as a citizen or a person, but we can abstract from a citizen to an entity and think of them in very similar ways. And again, I think that that purpose, if we just keep that in mind, it clears away a lot of difficulties and challenges, which I'll talk about next. And again, happy to put more into questions. There are three basic challenges to doing these things in my mind. One is just entropy, and I'll go into that in a second. The second is asymmetry. And the third, the easiest one to deal with, though probably the hardest one too, is hubris. Just extreme or extraordinary pride of different groups that are involved in these challenges. Entropy is just a mathematical problem, if you will. It is always harder to implement things than to do it. You can name things one thing, you can call them X or Y or Z. Actually implementing them successfully is an entirely different matter. And sometimes, using a humbler name helps us cut through the entity a little bit more. In the book, we talk about, instead of calling something an innovation hub, we call it, hard workplace for improving M&A. That's obviously a stupid name. Don't use that, but you get the idea, or workshop or development operation. Things that are very simpler and humbler help us set expectations that it's going to be really difficult to create something new and implement it. And the chaos of the world is against us. So we have to use these tools and these things to cut through them. Asymmetry, I'll give you a very simple example. If I'm doing an M&A deal, the amount of knowledge at my fingertips does not necessarily correlate to what I need at that moment. So knowing exactly what the right term I should use in the contract, in the acquisition agreement, there's a vast amount of data on that. There's a vast amount of data about which of these provisions blows up if there's a dispute. Which of the escrow conditions tends to go south and cause problems? What terms did the person on the opposite me ask in their last deal? All of that data may not be available at that exact time that I have to make a decision and draft, because it's 3 a.m. We've got 24 hours to close the deal. And if we don't do the deal, someone else is going to buy the company. And there's no time. How do you deal with that asymmetry? The way that every other profession has since time immemorial. You build a system and a platform, and you do research and development to figure out what that platform should look like. And frankly, Aon can help deal with that asymmetry, deal with both in Brazil and globally, law firms that need to develop platforms but need either funding or they need a risk transfer solution or things like that. That's an asymmetry between the lawyer who's in battle, if you will, lawyer in the courtroom, or you're in the middle of the deal, and there's not enough time to build a comprehensive system that would, enable you to get to the best answer and craft the best art at that time. So again, first is entropy, the second is the asymmetry of time. And how do you fund law firms? How do you fund law firm initiatives to do that? Another way of doing that is, again, partnering with your clients so that you can, or venture capitalists and other funders, so that you can build systems to deal with that. That's kind of obvious to many of the people on this call, but I do want to point it out as a fundamental challenge to most people. The most fun one, though, I think is really hubris. For attorneys, the hubris is that math has no relation to what we're doing. We're strictly craftsmen, and we can't encapsulate anything about what we're doing in that. Again, in this group, I don't suspect that's a huge problem or a huge belief, but it definitely exists in the profession at large. You cannot ignore the mathematics, whether it's in billing, or whether it's in revenues, or whether it's in how many elements of the procedure you're carrying out are successful or not. Attorneys are, like me, we're somewhat math phobic, and that is a signal that we actually need to focus on this enormously as a profession and hire, partner, work with, fund the quantitative elements of what we're doing so that we're enabled to do it. And for us as an IP lawyer, as a practicing IP practitioner, it's that the nerds in the intellectual property world have never learned to speak to the nerds in the finance and the C-level world. It's just an arcane battle in a dimension that is not on the radar screen of anyone. If there's a problem, something will happen and something will change, but only if there's a big problem. We're not really part of the transaction discussion. We're not really part of the discussion about, should we have this kind of asset in the first place? What is it worth? Is our system working? Those types of things we don't incorporate. So we need to get over our arrogance about mathematics. For engineers, it's the opposite. They don't understand that law actually is an art, and there's a craft to it, and that unless you really listen to the users, you will blow up. And we've seen legal tech companies like this, pure engineering focused. We ignore the lawyers. We know what to do with data. They flame out and go over the cliff and crash into the dumpster and blow up. I've seen it happen a lot. And these are very talented, very brilliant people, but you need to understand the law of art and the law and the art of law in order to be successful in this area. So you need the engineers and the attorneys in the same room, and designers too. Designers who I think I'm most thrilled about the use of design in the law, but we can also get arrogant as designers and fall in love with our process. The fact that, oh, look, we're whiteboarding things, we're brainstorming. Yes, we need to do that. And we need to not get pretentious about what we're doing that, because pretension is the thief of action. And so many people do a brainstorming exercise and have this amazing experience, and then it has nothing to do with their daily practice. So how do you take that design and then implement it? How do you address that design hubris? And I think the answer is delta R. Delta R is simply a qualitative formula that means, does process 2 deliver a higher ROI, or return on investment, than process 1 and its ROI? So have you delivered, including all the costs of the new process, have you delivered a better outcome to your client, net? If you simply have this qualitative formula in mind, it can cut past through a lot of the things we do that can get in our way. And with attorneys, the other arrow we have in our quiver is competition and outcomes. If you can show better competition, you're outperforming your peers, you're getting the deals, you're getting hired more often, that fundamentally is gonna change things. I think the other thing is that you'll see is non-Brazilians will come to Brazil and say, I have the solution for you. They are, I don't want to say they're lying, because I think they actually believe it. They will fail. And the reason they'll fail is that Brazil is actually different. Brazil has its own legal codex, it has its own legal language, and it has its own Brazilian elements. It has to leverage everything else that's been done all over the world, whether it's Google's latest NLP tools, or whether it's OpenAI's tools, or whether it's the experience of legal in North America. But at the end of the day, it will be a Brazilian solution, not a pure foreign adoption of something. And the other tool that I think we have that I'll say about this, and we'll jump to questions. In the US, we have, we refer to something called the Laboratory of the States. And I don't know whether the same is true to some extent in Brazil amongst the different regions and states. But we have 50 different states. None of them trusted the federal government as a constitutional matter. And so everything that's not on a short list is dealt with by the states. So you have different outcomes in different states. And ideally, you know, one state does something and they have a problem and it doesn't go well. The other states learn from that and they don't do that. You can really do the same thing from Brazil to the US and vice versa. Like our patent system has some really good aspects to it. We're processing patents 2 to 3 years, which is not crazy. Europe's patent quality in terms of is probably better than ours, especially for software. But you know, there are some good things to learn and there's some bad things to learn as well. And the same is true of legal tech. So use America and other countries as the laboratory for Brazil, rather than take the best of everything. In the last thing I'll say on experimentation is that one of the problems you'll face as an attorney is saying, well, I'm not going to, you know, do some crazy science experiment with my counsel, with my M&A deal. You know, it'll destroy the firm. We can't do that and we have a duty to be competent. So why should we experiment with our clients? It's actually not the right question. The right question is, why have we been experimenting so badly with our clients for the last few millennia, right? We've been conducting bad experiments for millennia because we haven't been gathering the history and the data of these things. So comprehensively gathering data, trying to simulate things before we enact a new law, these are very simple things we can do, or kind of role-playing what might happen in a lawsuit. That kind of simple simulation is something that engineers do, and they should do it well, and it should prevent buildings from coming down, and it should prevent other things from breaking in infrastructure. We're not doing that, and that's a fundamental difference in the way we think as legal engineers versus legal AI. Thank you so much for having me today. Again, I look forward to speaking with as many as possible. Look me up on LinkedIn, and would love to learn about what projects you're working on, and if I can help in any way, I'd love to. Thank you. Back to you guys.
So, thank you very much, Joshua. I think I'm going to start with a question for you. First of all, it's a privilege to hear your thoughts, your ideas, and especially some, I would say, some arguments that I would say that you are provoking us to think about how can we learn and how can we do things differently here in Brazil. But two things that caught my attention when I was hearing you. The first thing, when you compare, and I agree with you on that, but I would like to actually make a question regarding that point. You actually, when you were speaking about the governance and the meaning of the terms cyber, it caught my attention that you mentioned that in a way we could describe, and I know that this is just a caricature, we can describe the legal system as an algorithm to solve disputes, to in the end to solve problems. And one thing, when I'm discussing with a lot of lawyers here in Brazil regarding technology, and especially artificial intelligence, one of the things that strike them is what would be the impact on legal discretion? Because when we speak about the lawyer's career and what is the role of a lawyer in the Brazilian legal system, they usually will portray like that. They would say that the power that they have regarding the law is the possibility, or it's the opportunity to them to create a legal argument within the legal system and to try to convince a judge. So they would say that they have some creativity to actually try to solve problems representing their client, but trying to, in a way, beat the system, if I may say in those words. So one of the things that when we are thinking about artificial intelligence, it is, and in my view, you are looking to this idea that we could solve problems in a better way that we do nowadays. But for some lawyers' perspective, they would say that they will lose their power regarding not only representing their clients, but with this thing that is so important for them, that is legal discretions to build theses, to build arguments for judges. And my first question is, do you agree with this description? Do you think that artificial intelligence could help us to solve problems better, but in a way will impact the lawyers, I would say, making them losing part of their power? This is my first question for you regarding control. And my second question for you, it is the impact for law firms. Because here in Brazil, we discuss a lot of things regarding impacts of artificial intelligence in law firms. And two arguments are common, and I would like to hear from you regarding those comments. The first one, it's a very common argument, that is the substitution argument. Oh, we will have machines that will substitute lawyers and other legal professions in a law firm, and will reshape the way that we actually see the law firms. And my question for you is, do you agree with that? Do you think that this is true, at least in the short term? And the second one is, one main obstacle to think about not only innovation, but the impact of artificial intelligence in law firms. It is the idea that we have senior partners that will fight against innovation because they have the incentives to actually extract the most value that they can from the law firms within their last year in the firms, rather than invest in new technologies that could improve their efficiency, their productivity, but will show results for the next 3 years, maybe 5 years, and they will not be there to enjoy and to extract those values. So that is my two questions that I would like to hear from you. And again, it is a privilege to be a part of this project and to hear from you again. Thank you.
Thank you so much, Alessandro. It's such a privilege, and I hope this is the beginning of this conversation and real life impact in Brazil, not the end, because there's so much discussion to have, and I think in this case the parallels between the bar in Brazil and the bar in the United States are so close that they're the same. They're really not different at all, because they're exactly the same things we face. And again, starting in 2004, 2006, Picasso, I think, said, you should learn the rules of art so that you can break them like a master. You have to learn all of the things and all of the statistics and all of the data so that you know when to break them, and that there's a reason to do that in this case. I'll give you, and it's a fundamental question about discretion. That discretion can't be taken away. And what I've said, I said it to the South Korean Supreme Court, and I've said it to the US Supreme Court. It's neither possible nor desirable to replace judicial discretion with computation. And I think there's a lot of reasons for that. One of them is explainability. The other is uncertainty. The other is, how do people feel about those decisions? And I think you can see a couple of train wrecks. Here's one train wreck that arose because of the lack of data. In the US, we had sentencing guidelines about, when you sentence someone to jail for a certain time. Sorry, I should say, there was a disparity between if you were arrested for possession of crack cocaine or powdered cocaine. If you had crack cocaine, you're going to jail for like 20 years. Powdered cocaine, 2 years probation. maybe, or 6 months, or it was a massive disparity. It turns out that the people that were using crack cocaine generally were much more often African American, and the one using powdered cocaine were much more often Caucasian, to the extent those are real categories, which they may not be, especially these in the coming decades. But again, there was a massive racial disparity which violated the Constitution. So we redid sentencing guidelines so that it wasn't such a radical change between them. And Congress intervened, and judges had to think about these guidelines. They're called guidelines because the judges have discretion over them. But when there is no discretion, in patent damages, there was so much discretion that the same case in Texas, in Eastern Texas, or in Northern District of California or Delaware, you'd get 10 times more damages in one district versus another. So the court said, we need to have some framework for dealing with this. And the data enabled them to do that. So weirdly enough, I mean, the statistics have to be there because you have to understand that will become a mess, a chaotic mess, if we don't have some understanding of where the incidents of things are. But when you have an outlier, you can say something's wrong in this case. Those are things that I would argue empower judges. I don't think they hurt them. And I had one judge in San Francisco, federal judge. His brother was a Supreme Court justice. And he said, I hate patent cases. And I love your system because it helps me manage them more efficiently so I can focus on the life and death, the constitutional cases, the ones that he really likes. So that it's an empowering thing. I think it's the same for the law firms too. I think we're conducting orchestras. It's going to reduce scrivening. There will be some things that probably we do less in law firms, maybe paralegal tasks. But the good news is this: you don't have a choice. Like, we're going to get wiped out very quickly if we don't adapt things because our competitors are using it. Like, your competitor, the head of one of the top 3 law firms in Silicon Valley said, when we were launching this system, if my competitor has it, then I have to have it. There's no choice. So it's not really a choice if you want to be around in the next 3 to 5 years. And those changes can be very fast because all of a sudden they have it. It is partly true what you said. There was another really elite law firm that looked at the same system, the data, and they said, gosh, our special knowledge about these particular judges, it's now been democratized. Other law firms can see it. And you have, I had a client who was litigating in Georgia around Atlanta for the first time in his life, knew nothing about the judge, knew nothing about anything. And because he used this empirical system, he got the case, first of all, and he figured out how to win based on the data about how this judge had ruled. And again, often that gut of the local person is wrong. Sometimes it's really true, but they always know a lot. They always have a lot to add. But yes, it does democratize some of that information. But on the other hand, if you have data nerds, and they can be first, straight out of law school, straight out of FGV, they're going to have an advantage in terms of data analytics over others. And that's equivalent to kind of intelligence, really, in warfare. You have to do this, right? There isn't really a choice. But again, at the end of the day, all of this stuff is designed to empower discretion, and it's designed to empower the art of what we're doing. In my view, it's not designed to replace it, and most of the efforts that do that fail.
Thank you, Joshua. It was wonderful to hear you, and we are very glad to have you here.
Privilege.
I had a question to add when Alexandre Checo was talking. Since we are in a school today, FGV, a law school, and Zavaglia asked already, we would love to hear you more about how can we train our students for this future with AI. But I would like to add one question from Luis Damasio, that he's saying here that I heard some days ago someone was suggesting or even creating to have a high priority AI system to control other AI systems in order to manage the bias problems. I must say that I heard the same. Do you really believe on it, or you believe in the current AI algorithms improvements? So what will be this future? How do you see that? So thank you very much, and thank you for the audience for all the questions.
Obrigado, and please keep the questions coming through FGV or to me. I'm so grateful to be here right now. What a purpose. Yes, I think we have to use legal AI to manage AI. Again, I don't think we have a choice because the volume of decisions or determinations or classifications will be so high that there's no way to keep up with it unless you have countervailing reasons. And the reason is AI it's not as smart as we make it out to be, right? If you look at autonomous vehicles, the delivery dates keep getting pushed, at least the safe delivery dates keep getting pushed beyond what we're told. But AI is cheap and AI is fast. It's cheaper and faster than any of us who are practicing attorneys or who work in the law. So you have to have legal AI to manage AI. And I think the default with artificial intelligence is it will lead to massive bias. That's what statistics are. You're in this group, you will be classified as this. You grew up here, this is your pathway. It's a path dependency issue. And the other train wreck that happened on that was they did because of the pandemic, and I hope everyone is safe and things will get better, God willing, we'll be there very soon, as much as possible during this time. But because of the pandemic in the United Kingdom, they assigned people exam scores based on what they'd done that year or something like that. So they said, here's your grade. You didn't work for it. You didn't get it, but this is our guess as to what you got. And so therefore, and so it was a nightmare. And of course, everyone who, their mother had cancer that year they were dealing with, or again, they were in a group or locale that it looked like they were going to do badly. They were given the D's or the E's or the bad grades instead of what they would have actually gotten. And again, statistics are one thing, but to assign that to an individual and to assign university places based on that is a disaster. So lawyers are uniquely positioned to manage AI and the use of statistics and governance. But we're so slow and we're so good at shutting things down that no one comes to us. They avoid us. They avoid us. We're like zombies inside tech companies and no one wants to touch us. So what happens is you get this kind of parallel universe, like with contracts. What we need to become is two things. One, we need to learn technology that can be used for governance. And I'll talk about a little bit more about that concretely in a second. Second, we need to become creators, not just no-sayers, right? We need to be at the design phase, and I talked about that in the book. At the design phase of zero, you have a lawyer in the mix. I used to sneak in lawyers into aerospace design teams. He or she would dress the same as the engineers, would talk with them, drink the same beverages, like they were like inserted and camouflaged so that they were part of the creative team and they could make better legal design decisions, not just better aerospace design decisions, which could, again, cause huge legal problems. Again, you're gonna make people safe first and foremost, but having lawyers as part of those interdisciplinary creative teams is life and death. That's the way I would teach as well. And I think you don't need to be at Stanford to do this, but Stanford's done a good job about having lots of interdisciplinary degrees in law and computer science. And it took very brave decisions by the dean to do that. I was privileged to draft some of the descriptions of the new degrees we were creating. They have workshops with undergraduates and grad students from engineering and grad students from the business schools and grad students from, environmental sciences. And they all show up to these joint sessions and look at, here's a societal problem. We're gonna form tasks and we're gonna create stuff. And they use volunteers to do that. So I would workshop with people. I would give them a task, like it's your job to build something, not just to, yes, you're gonna analyze things. And I think when you do that practical thing, you learn the law much better. In 2002, we started a project called CIPIX, Stanford Intellectual Property Exchange. That led to a paper that led to something else, but it was mostly international students and us. And if you think it's hard to understand copyright law as a lawyer or as a regular human, try understanding it as a computer, right? As a machine. You have to understand the law really well to build an engineering system that's going to make use of those principles. So while you're doing the workshop, you're teaching the doctrine too, in a profound way that, look, people are different, but I learn with my hands and with what I see. And so there are a lot of us out there, and you can teach it and you can incorporate other things. So I think my answer to both is the same. We have a unique obligation for legal AI, and we should workshop the same. Very specifically, I have proposed in autonomous systems that you have a full legal subsystem, actually an engineering subunit that was specifically designed that would help address legal issues. Because the engineers build these things, but they don't have really good legal training or principles to do it. So I hope that was too long an answer to your question, but we've begun hopefully.
No, it's amazing because we are studying and doing our research on that fields about explainable AI, auditable AI, responsible AI, bias mitigation. So we are just in the beginning of this trip. There's a lot of challenge to address that. So Joshua, we could talk for hours here, but we have a last question because of the time from Vinicius. So Joshua, what do you think will be the key success factors or analytics or in predictive analytics? What's the key factors to the success of the analytics?
I think it's a great question. I think the first step is humility. And I said it many, many times. The beginning of wisdom is the fear of God. And even if it's not a religious statement, it doesn't have to be. The set of things we don't know will always vastly exceed the set of things we do know. So don't assume just because it's been 100 to 1 that it's going to continue at that rate forever. We see things in this world that are fundamental shifts that are black swan events, and they happen with some frequency. And if you make assumptions about a legal case, it can go sideways very quickly. With humility, but it actually drives you to get more data. So instead of assuming an outcome or you think, here's the merits of this case, and that's important, obviously, if you look at the outcome of every single similar case in that position, you actually, because these data are available, you have an obligation to look at all of the most similar cases in this corpus. And if you can do that, you can lever it in its background information. And you can say that this judge, she only grants this type of summary judgment order or this type of X or Y. I should focus my efforts most of the time on these things, unless we want to waste money or time or annoy the judge. So by looking at the historical backdrop, you actually, you're not predicting the future, you're predicting the past, but you're optimizing your strategy to win. And so I think of it as I think we are navigating a set of nodes between the past and the future. And that's the way to think about it. It's a shifting map. It's a shifting map of probabilities, but you know with certainty something's around here. And because of that, in a pretty large corpus of information, you can find your way. And that is the fundamental difference between legal AI worlds and probably what came before, is that now, I think in the past, we were very good at saying, here is the map. And now with data, we can say to the client, here's the route you should take, and here's the winds that are hitting you this way. And we can optimize that pathway much better. It's not a certainty. It's like flying a plane with a lot better radar. I hope I began to answer. Thank you so much for this. And I look forward to learning about your projects and helping in any way I can, educationally or otherwise.
We appreciate it. Thank you very much, Joshua. I'm going to switch to Portuguese again just to say goodbye for our audience, but it was a privilege, and I can speak on behalf not only on Marina's side and Alexandre's side, but on behalf of FGV. It was a privilege. Thank you very much to be a part of this project.
Obrigado. Thank you so much.
Bom, meus caros, minhas caras, infelizmente o tempo nos obriga a encerrar o nosso evento. Foi um prazer contar com todos vocês e, por favor, sigam as páginas ali da FGV para que vocês possam acompanhar os nossos próximos eventos e agradeço a presença de vocês e até uma próxima. Muito obrigado.
Obrigado a todos. Bye, Joshua. Thank you again. See you soon.
See you soon. Obrigado a todos. I'll hold you to that. Thanks, guys. Thanks,
We're
everyone.
waiting you here in Brazil in the next December. Let's work for it.
Let's work for it. Absolutely. Thank you all. Thanks for your stories.
Thanks.